All right, in a few minutes we will begin our afternoon's landlord-tenant docket. We also have several civil motions, 3, and 4 or 5 small claims cases beginning at 3 o'clock. So I have a lot going on here today. Mr. Kreitz, I've renamed you. I'll put you in the waiting room while we wait for John to join us. Should be ready to start shortly. All right, we're waiting for clock to tick.
Good afternoon.
Good afternoon. Good afternoon, Mr. Kreitz, Mr. Bush.
Oh, Judge.
Our start
Morning, Your Honor.
time isn't for 5 minutes. Feels like afternoon to me, I'm not sure, but we had a long morning. Let me get situated here.
Hello, Jamie.
Hi, John.
You're definitely working on the bearded look there.
Well, I was trying to keep up with Mr. Middleton there with his hair, but I'm about ready to give up, I think.
Yeah, it's a heavy burden. The defendants are not here. This is actually a third hearing. Bettina, they had filled out the applications with Keystone. What do you know about this one?
They are being processed. We're in the process of cutting them a check and sending it out.
Okay.
Landlords like to hear those words.
Oh, yeah.
You say they, though, did not Miss Andrews move out, or is she back?
I believe it's just Brian is there now.
Bettina, how much is the check for?
Your Honor, that information is with the fiscal department. I would have to go offline to check that information.
Could you go ahead? We'll wait for you. They're not here yet.
Sure thing.
John, do you have any free time this afternoon or tomorrow in your schedule to see me?
I would tomorrow morning, I'm sure.
Okay. 9 o'clock?
Can you just check for a second, Jamie? That's fine. We'll see you then.
Okay, thank you.
Right. The total amount for Mr. Beck is $4,500. That includes $1,500 in future rent.
My records show that would get them to the end of June. They would owe July.
Oh, that's good. He's got one more minute to be here. Let me call the case. This is file 21331LT. It's entitled Kreitz Rentals versus Brian Boek, Boehk, and Alexis Andrews and any others. We had a hearing first on March 22nd, and Keystone had not had contact with the parties. At that time, we learned that April Andrews had moved out and moved in with her grandparents. We set a second hearing on May 5th and indicated that they had prepared the application with Keystone. They were expecting $3,500 through April, and we continued it until today. Ms. Bettina Emery is here from Keystone and has indicated that they have processed the case and they're willing to pay $4,500 in rent, which according to Mr. Kreitz would pay Mr. Boak's rent through June. So what do we do here this morning, John, or this afternoon? The defendant isn't here. We've confirmed there's a payment. Will you do a conditional order of dismissal?
Yes, we would do that.
All right. Well, I like when these cases work out. I don't know what happens in June. Hopefully he'll be able to get some employment. There's sure a lot of people looking for help. All right, now Bettina's still, I guess, Bettina, you're off the hook till 2. Our next case is a termination of tenancy case. You're welcome to stick around, that's at 1:25. But our next non-payment case will be at 2, Deer Creek and Ertman. All right, well, perhaps Mr. Volk felt since he'd done everything with Keystone, he didn't need to appear, but they've confirmed that the rent's going to be paid. That's certainly good for Mr. Kreitz. And, all right, we'll be in recess on this matter.
Thank you, John. I'll see you tomorrow morning, Jamie.
Yep,
All right.
thanks, John.
All right, the next one is Bristle Arms, which is a public housing, and alleging a number of lease violations, essentially damaging the quiet enjoyment of the other tenants. So I don't think there's anything you can do on that one.
Okay, Your Honor.
All right.
I will be back at 2.
All right, thank you.
Thank you.
I'll be here. Good afternoon. Who am I speaking with?
Virginia Prouty.
All right, let me give you a name. Do you have the ability to do video?
No, I tried, and all of a sudden the phone call told me I'm on Zoom. And
You are
I'm
on
trying to
Zoom.
get back into it. Okay.
You're on Zoom with me, so this is Judge Middleton.
Okay, can you see me?
No.
Oh,
Can you see me?
no. I'm
All right,
sorry. I tried all morning.
Is this a landline or a cell phone?
Cell phone, and
All
I'm
right.
using my iPad to try and connect with Zoom.
Yeah, we should be able to do it with your iPad if you've downloaded the Zoom app, but
Oh,
we
I'm
may have to
sorry.
well, it happens a lot. First time people do it, it's very difficult, and once they get the hang of it, it's pretty straightforward.
Yeah.
My whole life has been
I'm sorry.
Zoom.
Just a second.
Yeah, can you tell me what time it is?
Okay, I'm back.
All right, we're waiting
Sorry,
for the
Donna.
attorney for your landlord to log in.
Okay. And I might as well go ahead and tell you, I'm getting help with legal aid, but
All right.
he's
Wait
not
a
going to
minute.
be.
We'll make a record here in just a moment.
All right.
You can tell us all at once. Here we go. Good morning, or good afternoon, Miss Osborne. Can you hear me?
Yes, good afternoon, Your Honor. How are you?
Good. Miss Prouty is here with us, but without video. I'm
Okay.
going to call the case. This is file 21501LT, Bristle Arms Apartment of White Pigeon versus Virginia Prouty. Ms. Victoria Osborne is here for the Bristle Arms Apartment from her office in Lansing. Ms. Prouty, I'm assuming, is there at her apartment. Ms.
Yes.
Prouty, as a defendant in a termination of tenancy case, your landlord is alleging that you are violating the terms of your lease and wants you to move. So the law requires that I advise you of these rights. Now, I'm not adverse to doing it, but the law tells me I have to, so I'm going to. As a defendant in a landlord-tenant proceeding, including a termination of tenancy action, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have a right to a trial by a jury or by the court. If the action is for non-payment of rent, the Michigan Department of Health and Human Services could be available to help you. But this is not a non-payment of rent case. They're asking to terminate your tenancy. If the plaintiff is agreeable, the Citizens Mediation Services, Inc. may be available as a possible source of case resolution. If both parties are agreeable to mediation, the court can contact Citizens Mediation to coordinate resources, and the court could facilitate that meeting. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment will stand. So essentially, it tells you you have a right to get an attorney and you have a right to a trial by a jury or by the court. Your landlord served a notice to quit on you dated February the 15th. They allege violations of the lease, section 15, 27, and 40. That includes health and hazardous issues. 27 is destroying the quiet enjoyment of other tenants in the premises, and 40 is unlawful activities on the premises. So they're asking you to move. Before we went on the record, you told me that you have contacted legal aid.
Yes, sir. Yes, Your Honor.
How recently?
Oh, as soon as I got the first notice. When was that?
February 15th.
Yeah. That's
All right. Now, the law says you're entitled to a second or subsequent hearing. And this is the first initial hearing where I advise you of the rights. But in a non-payment of rent case, there could be a stay of any eviction proceedings until the end of June. This is not a non-payment of rent case. They want you to move out. I'm assuming you do not wish to move.
No, Your Honor. I've been here for 30 years. This is my home.
Ms. Osborne, anything to add to this?
Yes, Your Honor. Ms. Prouty, we have had some serious concerns with other tenants being threatened and fearing for their safety. That's what the complaint is stemming from. We, as the apartment complex, we have reached out to her family to assist in trying to get Ms. Prouty some assistance or help of some sort, and they were not interested in that at all. We know that she's been here for a long time, and you know, we don't want to have to kick her out, but we cannot have her behavior continue and have our other residents feel threatened and have their, you know, have their safety feel threatened.
All right, well, in the normal course of events, I need to adjourn this at least 7 days, which would take us to May 10th. But I think I'm going to go 2 weeks to see if, in fact, legal aid does come in, and there could be some discussion.
Your Honor.
Yes?
Do I get to state my case?
Not yet.
Okay.
You will get a chance to state your case, but I'm continuing this for 2 weeks to Monday, May 17th at 1:45.
Okay.
Do you know who you talked to at legal aid?
Yes.
Who did
Rick,
you-
Rick.
Rick Kupfer.
Yeah, I can't say. Yes,
All right.
Your Honor.
Do you have an appointment to meet with them?
He's going to make one with me. He I haven't met the man yet. But yes, he plans on it.
All right, well, I'm adjourning this for 2 weeks. Now, let me say this. If we meet in 2 weeks and I make a finding that you violated your lease, I could order that you have 10 days to move out from the 27th of May. I mean, from the 17th of May to the 27th. So this is very serious business. And your landlord is expressing some concerns about the health and safety of other tenants. So,
Your Honor,
yes?
I have not threatened anyone. I swear on my mom's Bible.
All right, well, we'll sort that out once you get either counsel or we're ready to do it. They allege 3 things, 3 sections of the lease, 15, 27, and 40. So you might take a look at your lease and see what those sections say. But they involve quiet enjoyment of other tenants, health and safety, and criminal activity. So I'm not sure everything that they're alleging, but we'll get more into
I am not either. Sorry.
Well, I'm sure they give you some sort of a notice.
Yes, but it's
violations.
not clarified. I'm sorry. I have ADHD. I'm jumping in on you. I'm very sorry, Your Honor.
All right, well, we'll adjourn this for 2 weeks.
You
May
said at
17th, 1:45. Does that work for you, Miss O'Brien?
Osborne, yes.
Osborne,
145.
I'm looking at your name and I'm saying it wrong.
It's okay. I
Okay.
recently was married, and a lot of people get my name wrong. It's kind of
Osborne.
odd to
It's
get
pretty
used to.
straightforward. Osborne. Anyway, you're here, and she's here, and I'll be here on May 17th at 1:45. Perhaps if you do get legal aid, they can reach out to counsel and have some discussion before that date. Otherwise, we'll be here in 2 weeks.
Yes, Ms. Prouty, if you do get legal aid, please feel free to have them contact me, as we have already spoken once. I'm more than willing to work with you.
You spoke with Rick?
No, I spoke with you.
When?
Ms. Prouty, we spoke in the very beginning when you were issued your notice to quit. But like I said,
Who are you? I'm sorry.
She's the attorney for the apartment complex. That's one of the difficulties when you log in by telephone only. You can't see anyone.
Right.
So perhaps next time you can practice and come in with a video feed. But
I'll
anyway,
try real hard.
all right, I will see you in 2 weeks at 1:45.
Thank you, Your Honor. Have a great afternoon.
All right, thank you. All right, I'll remove
Goodbye.
you, Ms. Brown. Goodbye. Can I get rid of you?
You probably could, but that would probably involve.
I think I got you again in the morning too, I think.
I don't know. I haven't seen my pre-trial schedules, but generally you get those from me with just the offers.
Yeah. We have several matters set for 145. One is settled and we have 2 somebody disposition motions. So I'll put you in a waiting room until somebody else shows up.
Okay.
Good afternoon. Who am I speaking with?
Katerina Sutherland.
Do you have the ability to do video?
I do not.
All right, give me just a moment here. All right, I'm going to put you in the waiting room for just a moment. Don't go away, all right?
Okay.
Okay. About it then. Okay, I gave you the best interest. If you've got
Ms.
it.
Sutherland will be with you in just a moment.
Okay.
I had another case that I thought would be quite brief, but they haven't logged in. But both parties are here in this matter. This is file 21233GC. It's entitled Auto Park Ford versus Katerina Sutherland. This was a claim and delivery action having to do with the purchase of a Ford Escape. As I recall the facts, the defendant had one vehicle, Ford Escape, and it was destroyed or damaged in an accident. She went to purchase another one and the financing company wouldn't finance it. I did sign an order for possession pending judgment back in March. Mr. Rognes has filed a motion for summary disposition. The matter is scheduled for our hearing here this afternoon. This matter is complicated by the fact that Ms. Sutherland has a bunch of other issues tangential to this, and she worked at Auto Park Ford, and she sends pleadings in with very small print, and I have trouble deciphering it all. But let me start with you, Mr. Rognes. This is the time and date for a motion for summary disposition. Was the claim and delivery fulfilled?
Your Honor, we did receive the vehicle back on the date that the court ordered. This is really part one of an administrative matter to clean that aspect up. Insofar as the money damages portion of the claim and delivery action, defendant never addressed any of that stuff, and this is a C9 motion based solely on the pleadings.
As I understand the pleadings, The plaintiff is asking for the certificate of title for the escape and money damages in the amount of $1,980, $30 per day lease value from 1/11/21 to 3/16/21, the date the vehicle was returned, 66 days, plus a filing fee of $235, a service fee of $50, a motion fee of $20, and a statutory attorney fee. And you're asking for a total of $2,340. Is that correct?
Yes, sir, Your Honor.
All right, Ms. Sutherland.
Yes.
You are at a disadvantage because you're attempting to represent yourself, and I understand that you're not an attorney. You're doing the best you can. But this is a legal motion called a motion for summary disposition, where he's alleging that there are no material facts at issue and that you owe this amount of money based on the pleadings. In your responses, you talk about a number of things, including the way you were treated at the dealership as an employee and whether you were sexually harassed or entitled to unemployment or those things, but they don't go directly to the issue of the car. What's your response?
My issue is I was approved for the first car, and then I wasn't approved for the second car. And then because they're claiming it was because of I didn't have employment. Well, due to the fact that they had let me go because of the sexual harassment issue. Then I was told that it was because I made no payment. But when I purchased the first vehicle from them, they took my Jeep and they put that as a down payment as $1,500 for the Jeep, and then they took $500 out of my check every time I got paid, and that was supposed to be. And then they also, for the second car, for the down payment, it was supposed to be $1,500 again. They were going to take $500 out of my check every time until I got, but then they went ahead and let me go. I was never aware of that once they let me go, that they were going to take the car back. I was never aware of the situation and aware of that, and I was sexually harassed, and then they went ahead and let me go.
Well, once you got terminated from employment, how did you expect that the payment was going to be made?
I was under because when they let me go, they told me to put lack of work due to COVID and that I would get unemployment. I never got any discharge papers, so they told me that I could get unemployment.
And I don't know the answer to that, but the bottom line is they never took any more money out of your check and you never paid any money after that. Is that correct?
Yeah, correct.
All right.
But I
Andrew,
was under the impression that as long as I had my unemployment that I was going to be able to make my car payment and I was okay. And then I found out that they were coming to take the car and everything else.
all right. Well, no payments were made. Andrew, you're asking for this $30 per day lease provision. Where is that?
Your Honor, that's just the standard lease provision for any non-new vehicle from Ford.
Well, is it part of a contract?
No, sir.
Well, habit and practice of the auto industry, I don't think rise to the level of, let me see what was pled in the pleadings.
It's going to be in paragraph 5 of the supplemental complaint.
All right.
From February 4th. I mean, it's a claim and delivery, Your Honor. This types of things are, hey, you know, somebody's got our stuff and we're entitled not only to the stuff back, but compensation for their use of it during the interim.
Yes. There it is, paragraph 5. All right, Ms. Sutherland,
Yes,
based
Your Honor.
on the law, which is MCR 2.116C9, the defendant has failed to state a valid defense to the fact that you didn't. These other incidents, as Mr. Rognes argues, are collateral. Whether you were going to get employment, whether they represented that, whether you were sexually harassed or unfairly terminated, I can't determine. But as for the purchase of the car and the failure to make any payments, it's controlled by the contract. So I'm going to sign this order for summary disposition, which finds that you owe $30 per day under paragraph 5 of the original complaint from 1/11/21 to 3/16/21, the day the vehicle was returned. No payments were made on the vehicle, but you had the use of it for about 2 months, 66 days. They're also entitled to their costs. So the total is filing fee of $235, service fee of $50, motion fee of $20, and statutory attorney fee of $75. Total amount is $2,340, and I will sign it effective this date. Now, you're certainly free to pursue all of those other issues that you discussed, but in terms of this auto purchase contract, I'm ruling just on the 4 corners of that and on the pleadings. So we'll send this to are you still at the West Street address?
Yes.
You do have 21 days to appeal this, but that's my ruling, and I will send you a copy of it.
Okay, thank you, Your Honor.
Thank you.
Thank you, Andy. I've signed the order.
Okay.
Good afternoon, Mr. Groen. Let me get my ducks in a row on the last case here.
No problem, Your Honor.
All right, I was hoping you were going to come today and report some good news for me.
Well, it's mostly good news.
All right. Let me call your case. This is file 201478GC. It's entitled Citibank versus David Hartman. Mr. Brian Groen is here on behalf of Citibank. We were here on March 29th, and the defendant was working with a debt settlement consolidation company, and there was some hope they were going to resolve the matter. So I continued the matter until today, and the defendant is not here. Mr. Groen, what have you got to report?
What I have to report, Your Honor, is we normally send 2 documents to the POA. It's a settlement agreement as well as the consent judgment. We got the settlement agreement back signed by Mr. Hartman. Unfortunately, we have not received the consent judgment back signed by Mr. Hartman. But both the March and April payments pursuant to the settlement have been made. So it looks like the payments have been entered by their power of attorney. We're just kind of waiting yet for the signed consent judgment. And I'm thinking I'm going to probably have to resend that. And I might send a copy directly to Mr. Hartman and maybe bypass the middleman in this instance.
All right, waiting for the return of the consent judgment. He just may not have understood what he needed to do. How about if you can, is 2 weeks enough?
Yeah, probably not, because if I have to remail it to him, sometimes it takes almost that much time just to get to him.
All right, we'll continue this for another month.
That sounds reasonable, Your Honor.
Monday, June 7th at 9:30.
So June the 7th at 9:30?
Yes.
Okay. We'll put that on our records.
Monday morning pretrial docket.
Okay.
Okay, thanks.
Yeah, but like I said,
I think it is settled. And of course, if the consent judgment comes in the meantime, we'll simply dismiss it.
We will notify the court and let them know that it has been resolved and no need to have that hearing then.
All right, thank you very much. Enjoy the rest of your day.
You as well. Thanks.
Bye. All right, we have another landlord-tenant matter at 2, which is 4 minutes from now. Whoops, so I will make a record on this case. File number 201693, Jefferson Capital Systems versus Brian Troughton. I have received a dismissal order from Mary Jane Elliott's office, signed by Judge Pattison in my absence. So no one has appeared on that matter, and it is dismissed with prejudice. I had thought this case might have been settled also.
Hello again.
Thank you for coming back. You missed a lot of really exciting stuff, so I'm sorry that you weren't here for it, but
Oh no.
we managed to get through it.
Okay.
We've had 2 previous hearings on this case. We were here on March 19th and April 5th, and I was hopeful that this matter had been resolved. Back in April, you had their application, and I'm talking about Deer Creek versus Ertman, 2123. Were you able to provide assistance in that case?
Yes, Your Honor.
I'll let the clock tick for a minute here.
Right now we're very limited with one bedroom. I don't want to keep, I don't know what, like,
Well, these are all short-term success stories. We get the landlord paid, we get the tenant's rent caught up. Hopefully at some point things will return back to normal and people can start to pay their rent in a timely manner and not lose their apartment. Well, no one is here, which leads me to think perhaps there's a settlement in the offing. I'm calling the case formally. It's Deer Creek Townhomes versus Alicia Ertman, file 21323. Mr. Tyrone Fleeman was here on behalf of the Bradshaw firm back on March 19th and again on April 5th. On April 5th, the defendant was in the process of being processed for assistance by Keystone. Our housing advocate, Bettina Emery, is here on behalf of Keystone. She indicated they were able to provide some assistance. What were you able to do here?
I believe we got her caught up on rent, and we also assisted her with future rent.
Someone is coming in who's alleged to be Tyrone Fleeman or a sunset on the beach. We'll see who comes in. Here he comes again. Well, we lost one and we're bringing in the other. He usually doesn't have connection problems. I'm not sure what's going on here.
Well, hopefully the second time will be the charm.
Well, he's in there twice again. Let's admit this other one. Good morning, Mr. Fleeman, or good afternoon. All right, we're down to just one Tyrone Fleeman. And he unmutes his mic and we'll be good to go. Now unmute. Are we there?
There we are. There we are.
Somebody in your building is running a telemarketing scheme or something. They're using all your bandwidth.
That could be.
But,
That could be. And at least they put themselves out as Judge Middleton. That's what they did.
Well, that's a scary thought. We're here with Bettina Emery from Keystone, and she was about to inform us in this file 21323 that they were able to provide some rental housing assistance for these parties. Bettina, can you tell us how much was paid?
I apologize. I have to go grab that information.
Well, Tyrone, can you tell us?
Yeah, I've got it in front of me. They're paying a total of $44.76, but that's the back and forward. It looks like rent arrearage, they're paying $1,995 for back rent, and the rest of it's going toward forward rent. What I didn't know, that my client just sent me the settlement agreement, but Bettina, have you guys already sent that check or just the paperwork?
It should be on its way in the mail.
Okay, so the check has already been cut. So Judge, I think at this point, we could probably go on ahead and dismiss this file. I don't think we need to adjourn it out. Normally they, kick it out for another 15
So
days.
do you have a conditional order of dismissal there?
I don't have a consent. I can generate a voluntary dismissal and send it to you.
All right, that would be fine.
That's easy enough. For that matter, I could probably use the judgment form, couldn't I? Yes.
Let's see what I've got here.
I've got the judgment form already pre-printed. I can just write in the further orders, case dismissed.
Yes, let's see if I had one. The check's in the mail. I only had 2 beers.
I don't normally trust that text in the mail, but Bettina seems pretty trustworthy. So
I'll still respect you in the morning. And I'm sending you a conditional order of dismissal.
That's
All right, we'll wait for the voluntary order of dismissal, or even on the judgment.
I will generate that dismissal and send it in to you. I don't know if I'm going to do that yet today because the person that normally runs those is not here.
All right, that's fine. We'll be tomorrow.
It will be forthcoming.
All right, thank you.
Thank
All right,
you.
that finishes the landlord-tenant portion. Thank you, Tyrone. I'll see you soon.
Have a good one. See you, Bettina.
Bye.
All right, Bettina, you're off the hook too, unless you want to sit through 5 small claims trials at 3. But otherwise, I have a judge conference Wednesday or Thursday and Friday, and those days were blanked out. But I'll be back in the afternoon, so I've scheduled cases for Friday the 7th in the afternoon. So I guess I'll see you Friday afternoon.
Yes, indeed. See you then.
All right, thanks for your help, and thanks for helping these people today. You got at least 2 people that got their rent paid through June.
Yeah.
Helps you sleep good at night. All right.
Oh, yeah. Thank you.
Okay. All right, we're going to stop our live feed. We will be back at 3 o'clock for